everybody. It's 12:01 on my computer. Just to be respectful of all of your time, we're going to go ahead and get started. My name is Eileen Smith. I'm an associate in the Decatur office. I'm also the broker who writes all of the 10-day letters for the Keller Williams Heart of Atlanta group. So today's topic is going to be the 10-day letter process. How many people here have never heard of the 10-day letter process? Can you show me a hand? Okay, so I'm going to assume that everyone has at least heard of the process. Is there any?
I can't find my hand.
You can't find your hand?
I'm raising my hand.
Okay, all right. So just for everyone's information, the 10-day letter process is something that we have to go through as brokers when the buyer and the seller don't agree and won't sign the TNR. If you've ever had a buyer that signed the TNR and the seller said, no, I'm not going to give them their earnest money back for whatever reason, then earnest money becomes in dispute. And once earnest money is in dispute, the only way to resolve it is by going through a process called the 10-day letter. It is not something you can do on your own. It is something that has to be performed by a broker. It's something that in the past Tom has done, but now that he's responsible for so many offices and gotten so busy, he has asked me to take over that responsibility. So what happens is when earnest money is being disputed, I have you all fill out a form, and I'll show you that form shortly. I've sent it to all of your offices. Your team leaders have it and your MCAs all have it. But if for some reason, excuse me, they can't find it, I will put my email address in the chat and you can email me and get a copy when you need one. I hope you never need one. But when the buyer and the seller do not agree on how earnest money is going to be dispersed once there is a contract termination of any nature, then I have to get all of the information from both sides of the transaction. I talk to the buyer's agent, I talk to the listing agent. I do not talk to the clients. I only talk to the agents. I have a list of documents that I require. I require all of the contract documents, all of the amendments, all of the exhibits. And in many cases, I require copies of emails be forwarded to me so I know when things were delivered. And then based on all of that information and an interpretation of the contract, I write a letter. That letter is mailed to all parties, at least to the clients, and mailed to the other agent. Typically, an agent in our office will just get an email copy as well as your team leader and your MCA. And you are free to email that to your clients. The email copy of that formal letter states that there is a dispute for earnest money. Who is holding earnest money? Of course, we have to be holding the earnest money. And then based on the interpretation of the contract, how earnest money will be distributed. Then the recipients of that letter, including agents, brokers, buyer, seller, have an opportunity to dispute my findings in writing. They have to send me an email or a letter. Either one will work. That it needs to be addressed to me. And then if they feel they have information that I have not already been presented that may change my determination, they can present that information to me. If there is information in there that I was not previously presented that is relevant to the situation, I can change my decision on who will get the earnest money. So I have done that once or twice. That's why I try to up front get everything I can from the agents that are involved in the transaction before I actually send out that letter, because it's not good form to have to change the ruling and disperse earnest money to another party in the transaction. In some cases, earnest money is split between the buyer and the seller. It depends on the specific situation. But that is the 10-day letter process in a nutshell. Any questions from anybody before we move on? Okay, I don't see any hands and nobody is talking. The 10-day letter process is something that brokers are required to do by the Georgia Real Estate Commission. The danger that you guys run into is when you let attorneys hold earnest money. Attorneys are not required to send out a 10-day letter. They are not taught the real estate law as we are. Granted, they're attorneys, but they misinterpret the contracts all the time. And their interpretation of the contract could be different than a broker's interpretation. I have in many years past, when an attorney was responsible for holding the earnest money, the party that should have received it, had a broker interpreted the contract, did not get it because the attorney just sent the earnest money to whoever asked for it first. Or an attorney will say, well, we're going to take a look and we'll get back to you. And they come back and they say, well, it's inconclusive, so we're going to split the earnest money. And then there's no recourse for the buyer or the seller. So attorneys holding earnest money is a real catch-22. You really want to, because particularly in our offices, we have escrow accounts. We have the ability to hold earnest money in all of our offices. If you have an agent that you're co-oping with on the other side, whether it's a buyer's agent or a seller's agent, you want to convince them to let your broker hold the earnest money. So if there is a dispute, it can be distributed according to the interpretation of the contract and just not the whim of the closing attorney at the time. Does that make sense to everybody? Are there any questions about that? You guys are a lively group today. Okay. I am going to share my screen and show you the 10-day letter. And where did it go? Got too many windows open and that's why it's not coming up. Hold on. Okay, so here is the 10-day letter request form and checklist. So again, your MCAs and your team leaders have all been provided with this document, but in the event that you run into having to start the process for a letter being written and can't find it, I put my email address in the chat. You just email me directly. I'll send you the form. First question is your Keller Williams office holding the earnest money? That's important. I've gotten these forms and the office isn't holding the earnest money. If one of our offices in the Heart of Atlanta group is not holding the earnest money, I legally cannot write the letter. So it has to be held by our office. And then I ask, have all efforts to obtain a signed termination been exhausted? Because I have run into situations where, say, a buyer's agent sent out a TNR to the listing agent. The listing agent never responded, never acknowledged receipt. The buyer's agent sends me this form and fills it out and says, we need a 10-day letter. And I call the listing agent and they say, oh, I didn't get the TNR. Or, oh, I tried to call the buyer's agent and they didn't call me back. I want to make sure that in addition to sending the termination over to the co-op agent, that you've at least tried to call them on the phone and talk to them to find out why the other side is not signing the termination. Because I'm going to talk to the other side anyway, so you might as well help me up front. Then I need the property address, the amount of earnest money being held in the specific office holding that earnest money. Since I do write 10-day letters for 6 offices, I do need to know which office you are in. I need the buyer's name, address, and email. I don't need their phone number. I'm not going to talk to your clients. I need the buyer's agent's name, brokerage, office address, phone, and email. If that's you, that's fine. Fill in your information. If it's not, fill in the other agent's information. Then I need the seller's name, address, and email. The reason I need the buyer and the seller's name, address, and email is in some cases, buyers and sellers are out of the country for extended periods of time, and I have to mail them a letter. But if they're not in country, I have to at least email them a letter to make sure they receive it and have an opportunity to respond to it. And if you don't have their address and email, please call the co-op agent and get that information for me. Because again, I have to get that letter to them in some way, shape, or form. I also need, of course, the seller's agent's name, brokerage, office address, phone, and email. And then a brief explanation of what happened and why the other party to the transaction won't sign the termination, what led to the termination and why they won't sign it. You can write it on this form. You can put it in an email that you send to me. And then a list of documents that I need with this form are the purchase and sale agreement with all exhibits, all amendments written on the contract, a copy of the earnest money check and proof of deposit, if it's the Earnest app, whatever it is, proof that earnest money was delivered, and then proof that earnest money was deposited. That's extremely important because sometimes earnest money isn't sent at all. And a copy of the termination with at least one set of signatures on it, and proof that that termination was sent to the co-op agent and when it was sent to the co-op agent. Because I've had terminations that were sent the day after or 2 days after the contingency expired that they're terminating with, and that's just not going to work. You were wrong in doing that. You needed to send it within the specific time frame. So I need that proof of delivery, excuse me. And then you send those documents to me and Tom. If there are any other documents that I need from you, once I've looked at everything, I'll let you know. But it's just a 2-page form. You can fill it out online in Acrobat. You can handwrite it and scan it back in. It really doesn't matter to me which one you do. But what I need you all to understand is I'm in the Decatur office. I do not have access to Command.loop, any contract writing platform you happen to be using in your office. So you have to physically send me PDF documents. The agents in the Decatur office, I can look at their documents in Command, but every other office in the heart of Atlanta Group, I cannot see those documents in your system. I do not have access. So that's pretty much it. Does anybody have any questions about the process or anything that I've explained so far?
No questions for me.
Eileen,
Hi, Barbara. What's up?
how are you today?
I'm good. How are you?
I'm great, thank you. I just wanted to add on to some comments that you just made. Two in particular was the proof of the earnest money. When we send proof of the earnest money over, sometimes people will, I know they used to provide like a personal check. And I would always advise my people to not send a copy of that personal check because it gives so much information from that buyer. It's going to have their account number on there, their routing number. It's going to have their address on there. So I would always advise them to always send another form of proof that earnest money is deposited. And I love Earnest because you get confirmation that the earnest money was received. And that's what I generally send as proof of the earnest money. And
that is correct. But if you're getting personal checks from people, You can take a copy of that check and you can black out the routing information. Blacking out their mailing address and their phone number, that's information that should be in the contract anyway because it's needed by the closing attorney. But you can make a copy of that check. You can black out their routing number and their account number, and then you can send that copy of the check to the other side. The problem is you have to have a real copy of the check with the routing and account number on it for the lender. The lender needs to know what account that money was deducted from, and they need to see that full copy of that check.
And the other thing that I wanted to say too, Eileen, is you mentioned that sometimes when you go to check for the earnest money that it hasn't even been received. And that's something we have to really be careful about. I make a note when I'm supposed to get that earnest money so I can go back and follow up and make sure that I received it, because just because I didn't receive it doesn't void out my contract. It's other steps I have to take. But then you also have you don't have any issues with anything until there's a dispute. Then when there's a dispute, that first thing that comes up is that earnest money. Then you go back to look and see that it's not there, but when you get a dispute, they darn sure are not going to give up that earnest money at that point. And then the realtor will be left on the hook.
Correct. And I've had several instances over the past year where there was actually mishandling of earnest money because it was not tendered. If you're not representing the buyer, not responsible for collecting the earnest money, as the listing agent, you are responsible for making sure the buyer's agent collected the earnest money and you get a copy of that. I had an instance just last November, December, where the seller refused to sign the termination and release to give the earnest money back to the buyer. And the buyer clearly was due their earnest money back, and the seller agreed. But because they had never gotten a copy or proof that earnest money was delivered, he didn't feel it was necessary to sign the termination because he didn't think there was any earnest money to be given back. So that is very important. Thank you, Barbara. We have iPhone has their hand raised.
Yes, I'm sorry. It's not showing my information.
It's not.
Well, I'm sorry. Well, this is Tawanda Hank, and I have a question. If I'm not mistaken, and I want to make sure I'm clear on the understanding because I took a class, and if the earnest money isn't turned in within, let's say, the 3 days that we actually applied to the contract, and it's turned in after, do we still need to add an amendment with it stating that it was turned in after the 3 days, or?
You do need an amendment to change the delivery or the receipt date for the earnest money, or that is mishandling of earnest money.
Gotcha. So if it's turned in on the 4th day, we need an amendment.
You need an amendment signed by all parties saying earnest money was delivered on such and such a date, and get everybody to sign it and agree to it.
Okay, gotcha. Thank you.
And that's another thing, in the contracts, we're supposed to specify in what manner earnest money will be delivered. And that manner is cash, check, ACH, or wire. Now, we can't deliver cash. Nobody accepts cash. Even closing attorneys don't accept cash. But the Georgia Real Estate Commission is required to put cash as an option in the contract because cash is a legal form or a form of legal tender here in the state of Georgia. But we cannot accept cash. Now, the other options are a check, money order, wire, or ACH. You cannot check more than one box. You can only check one box. And then if you check that the buyer is going to give you a check and they actually deliver the earnest money by wire or ACH, again, as stated earlier, you need an amendment to the contract specifying the change in the method of delivery of earnest money. So it is not correct or legal to check multiple boxes on page 1 of the purchase and sale agreement just because you have not had the conversation with your buyer about how they're going to deliver the earnest money.
Miss Eileen, I actually have another question, and it's not regarding the earnest money, but it's a broker question. And someone asked it to me over the weekend while I was teaching a class, and I definitely, so is this only for earnest money or any broker related questions?
No, I can answer another question, but let's finish with the topic at hand and then we can go there. Is that all right?
Okay, gotcha. Mhm.
Okay, Barbara, did you have anything else to add to this conversation?
Just one more thing I wanted to say, and I had a situation a few years ago where there was an earnest money dispute and the closing attorney was actually holding the earnest money. And that was probably the last time a closing attorney held my earnest money outside of maybe Luther, Larkin, and Hunter because they're in our office. But in regards to what you said, Eileen, that attorney did relinquish that earnest money to the other realtor without my knowledge, without me being contacted or anything. But after I contacted him and we had a one-sided conversation, he made sure that Keller Williams was compensated.
Oh, well, that's good. That's good because I've had attorneys twice in my career that dispersed earnest money incorrectly, and my clients in both cases lost out because the attorney was not held to any specific standard in doing so.
Yeah, well, in that situation, the attorney his books probably came up a little short because he did take care of Keller Williams after I got to talking to him.
And he should have. And the same with you guys. If you do something incorrect that causes your client to lose the earnest money, if you're representing the buyer, the seller is probably a little different situation. But if you're representing the buyer and you didn't follow the contingencies in the contract for termination, due diligence, finance appraisal, whatever it is, and it was your mistake that caused your buyer client to lose their earnest money, you should be reimbursing your clients.
Mm-hmm.
It's not a requirement, but we've got someone right now that's threatening to sue Keller Williams. And it was a buyer and they lost their earnest money because the agent made a mistake and now they want to take the brokerage to court. And that's not the way we should be behaving as realtors. We are realtors for a reason because we are held to a higher standard.
You're absolutely correct, Eileen, and we need to also re-emphasize that they can lose their license behind mishandling of earnest money and things of it. Those things are very, very serious, and we take them very serious. And we work too hard to get our license, so be careful and don't lose them over little things like that that can grow up to be really big things.
Correct. Yeah, this buyer is also threatening to go to the commission and file a complaint. So yes, it'll be against that agent.
And you know, another thing, it's easy to, because I actually was in a situation where I had to pay back $1,500 to a borrower because me and the agent were going back and forth and couldn't come to an agreement with the appraisal contingency. I mean, with the appraisal coming in lower, we were going back and forth. And the deadline ended up expiring at 11:59 that night. And what I should have done was submitted a TNR, a termination, even if it was reinstated the next day. But me waiting on them, I forgot the deadline, and we pretty much went forward past it, and we got in a TNR situation. Funny thing is the attorney, Campbell and Brandon, the attorney that was over it, because they couldn't come to an agreement, he never moved it forward. A couple months ago, I just received a call from that attorney's office, and the attorney that is on the case now, because the previous attorney isn't there no more, he insisted, he basically encouraged me to have my client just accept half of the attorney. Like them split the earnest money 50-50. But in the interim, my client actually to me should have gotten her earnest money back, given the circumstances of what we had went through. But they end up just coming to an agreement. But I had already paid her back her $1,500, but the attorney sent the buyer and the seller half and half of the check, because he said if it moved forward to court, they would have, like, majority of the money would have gotten eaten up.
Correct. And that's why we don't like for these things to go to arbitration or go to court, because it ends up costing more than the earnest money that's sitting on the table. But yes, my husband's also a realtor, and he made a mistake, and he wrote a $4,000 check to his buyer because he made a mistake. So you guys, you need to be responsible for your mistakes. And sometimes you have to write a check to do that. So are there any more questions about 10-day letters and earnest money before I take other questions you might have?
The only other thing I want to add before we move on, Eileen, is just remember, guys, that non-receipt of the earnest money does not automatically terminate your contract.
Oh, absolutely not. Absolutely not. And you are in jeopardy of having a problem with mishandling of earnest money. There's been 10-day letters that I've been requested to write where there was no earnest money delivered that should have been. And that is an ugly, ugly situation. And most of the time, agents that fall into those situations end up getting their license released. So yes, you got to be very, very careful with that. Yes, Mika.
I had this before. So for everyone, if I'm the listing agent, the buyer's agent and that side does not remit the earnest money, what are the steps that should be taken from the listing side to acknowledge that that has happened, that we don't have any earnest money? Since we can't terminate the contract, what should be the next steps if that were to happen?
Yeah, you need to contact the buyer's agent's broker.
Mhm.
And if the broker is not willing to step in and do anything about it, then you contact me or your team leader or me or Tom, and we'll step in and talk to that broker. But at that point, we would probably recommend that you write an amendment that no earnest money has been delivered, or your seller may prefer to terminate the contract because earnest money has not been delivered in the timeline that was dictated in the contract.
So if that
Eileen,
were
can
to
I-
happen and our seller says, I want to terminate this contract, we would send over
You'd send a termination and release saying no earnest money was tendered, and that's the reason that you were terminating.
Thank you.
Barbara?
Eileen, can I
Yes,
add
ma'am.
something?
Yes.
Number 7 in our purchase and sale agreement, it answers that question. If you don't receive the earnest money, usually our loopholes are included in our contract, guys. And I know we made a lot of changes to them last year for 2023. But if you don't receive the earnest money, it tells you in number 7 of the purchase and sale agreement on page 3, how to handle that. Because if you don't receive it, you, like Eileen said, you're supposed to contact the other party, their broker, and you're supposed to give them a certain amount of days to get that corrected and rectified. And so there are a couple of little steps that you take before you can actually terminate that contract. And your loopholes are in number 7, that's titled earnest money on page 3 of the purchase and sale agreement.
And that's a good point. You guys need to read these contracts. You know, you need to read the purchase and sale agreement in detail. You need to read the finance contingencies in detail. It blows me away that when an agent loses their client's earnest money, they go, where in the contract does it say that? Well, you know, you've got to read the contract. It's in there. I promise you it's in there. I teach a class here in the Decatur office once every 2 months, and it's called a purchase and sale agreement deep dive. And we read the purchase and sale agreement. The class takes 2 to 3 hours to go through it. And people are amazed at the actual content. So yeah,
Wow.
you need to read the contracts that you're using.
Mhm.
And one more little shameless plug, Eileen, I am going to do a 3-hour contract update class at the Camp Creek location for anybody interested. We'll send a flyer out. It's going to be held on February 23rd. It will be continuing education hours for anybody who wants to take it. They'll get CE hours also. And we're going to do a deep dive into those contracts.
Yep. So yes, thank you, Barbara. I appreciate that. So any more questions about earnest money and 10-day letters? Okay, so we have at least one other broker question. So if you want to go ahead, I can't remember your name. I'm sorry.
Tawanda. I'm
Okay,
sorry.
thank
Normally my picture would be up there. I don't know with the phone today, but neither here there. It's Happy Monday. My question is, because someone we were discussing over the weekend, I taught a class back to the basics, And I kind of went over that like with the agents about how they should just be, on the downtime, because a lot of them were newer agents, just learning the contracts, understanding the contract, so you can pretty much explain it like, the back of your hand. And I remember in my contract class, it was basically stating that when you get a listing agreement, you're not supposed to get the listing agreement signed. Am I correct? At least 48 hours before entering the listing in the MLS?
That used to be the case, but they have now changed the form so you can have a future market date. So if your market date and your agreement date are similar or within 48 hours of one another, yes, that is the case. But now on the listing agreement, you can sign that listing agreement today with a market date of October 1st if you want to. I strongly recommend to agents that they not do that. But that market date can be any date in the future. Agents seem to believe if they get their seller to sign a listing agreement now, and they have a future market date that's 30, 60, 90 days out because the seller needs to do some renovations or make some changes, that they've got that seller locked in and they can't list with anybody else. Well, that's true and that's false. You do have the seller's name on a contract. You do have to go into FMLS and you have to put that listing in as a registered listing. And the days are now ticking on the number of days your property's been listed. And if you make it live for market 90 days later, you've already got 90 days on market when you really haven't been. That's another point. But anyway, you have to put it in as a registered listing. And because it hasn't gone live yet, and even if it does go live, that doesn't stop your seller from saying, oh no, I changed my mind. I want to list with Barbara now. So we need to terminate this. Again, I don't recommend, I teach contract classes once a week here in the Decatur office to the brand new agents. And I tell them, just wait, get it signed. Don't get it signed more than 7 days in advance, but I completely recommend 48 hours in advance at the most. You get them to sign it and then you put it into the MLS the next day or the day after. But that used to be the case, Tawanda, and it is not anymore.
Okay, so you recommend at least 7 days and
no more than 7 days.
No more than 7 days, but still. So if, let me make sure I'm clear on the understanding. So what you said, it used to be the case. So basically right now, if I was to get a listing agreement and the future date is 60 days away, you don't recommend doing that. Do you still recommend getting an updated signature on that within the 7 or the 2 days? Even if
No,
okay.
you don't have to do that. You've got a market date. If it isn't going to go live on that date, you do have to do an amendment to change the live date. But the problem is you do have to put that listing into FMLS as a registered listing, and your market days start ticking the day you do that.
What is the time frame with putting it in the MLS as a registered listing from getting it signed?
24 to 48 hours if it's not going live.
Okay, gotcha. What days do you teach the contracts class over at the Decatur office, and is it open to all agents?
And yeah, anybody can come every Monday at 1 o'clock. So we have to be done by 12:55 because I have to run in the other room and teach.
Okay, cool.
So I teach a different set every Monday.
Okay.
If you want to email me, if there's a specific set of contracts, 1 week's buyers, 1 week's contingencies and exhibits, 1 week sellers, it's a 5-week rotation, but I can, if you're looking for something specific, let me know and I'll tell you what week I'm teaching it.
Okay, awesome. Sounds good. And thank you for clarifying that.
No worries. Barbara?
Yeah, here I am again.
Well, you're on the forms committee. You know why they did what they did.
So I just want to just kind of piggyback a little bit on that conversation there. And so in the event she has a future date that she's going to list the property, as soon as she opens that door up for someone else, she needs to go ahead and get that listing into the system.
Right. Yep, that's why I tell my agents, if you're getting it signed, you've got a future date. You have to put it in as the registered listing. I call it peeing on the tree. Because you're putting the MLS on notice that you have a signed agreement with this seller and no one else can put that listing in as long as you have that signed agreement with the seller.
So is that would be under the coming soon, right?
No, it doesn't have to be coming soon. It's just a future market date, and you can put the coming soon was limited to 2 weeks. Coming soon is, putting in pictures and actually putting all of the information in. When you put a listing in as a registered listing, all you do is you put in the address information, you put in your contract date, and you put in your market date. That's it. You really don't have to put in a lot of information to put it in as registered. You don't have to have pictures yet because generally somebody's going to be doing renovations. Coming soon is limited to 2 weeks, and you have to have all of the information in the listing and recommended that you have pictures. And then of course that's only available to agents.
Thank you. Is it a requirement with KW to put listings in both Georgia and FMLS, or can you just mark it in Georgia MLS and not have to FMLS?
No, you have to put it in FMLS because Rick is a member of FMLS, and the broker members of FMLS get checks at the end of the year on the profit that they make. So we have to contribute to that.
Gotcha.
So does anybody else have any other kind of broker questions? I can certainly do my best to answer them. If I can, I think probably Barbara can, especially forms.
Speak now, ask your questions, because you got 2 great brokers on him.
Okay, well, thank you, everybody. I appreciate your attendance and your interest in the 10-day letter process. So again, if you want to brush up on any forms or if you have any questions, you've got my email address, but I do teach contracts classes every Monday here in the Decatur office from 1 to 3. So you're welcome to attend at any time. But thank you for today.
I do have a quick question before you leave with the contracts. Do you have like a pre-existing stipulation list of steps that you're currently using in this market outside of the ones that, because the ones that come in the forums, it's so many of them. Like, is there like a standard list that maybe you teach in your class that everyone should be utilizing currently, or that's actually good to be utilizing, so you're not overdoing it but not underdoing it as well, still protecting yourself?
I do. I have a STIPS class.
Okay, and that's when is that?
Let me see when the next one is.
And Barbara, on Mondays, do you have any virtual?
I will check to see if we are gonna hold it virtual, and I'll let you guys know. But right now, we're gonna have the class on February 23rd after you guys get back from family reunion.
Received. Thank you.
My pleasure. Because when I put the flyer together, as a matter of fact, I'll be sending it over to Nayali to send out to everybody. And I'll send it to you too, Eileen.
Okay, thank you.
Yeah.
Hey Barbara, this is Phyllis. How are you?
Hi, Bill.
Hey, have we talked about the all cash exhibit form? Have y'all talked about that on another call?
Not that I know of, but Phyllis, we did make some changes to it based on what you said, and I sent it over to you to kind of look at it and see what you thought about it.
I did see it. I just wanted to know if y'all had talked about it prior to, but I did get it and I appreciate it. But, I had a doozy with that form, that all cash exhibit, and then they could still turn around and still do a loan. But yeah, I did see the changes. I just wondered if anybody else had brought it up and had a discussion on it.
We haven't talked about it here, but maybe Miss Eileen added to her list.
Yeah,
Okay.
I've also asked Tom to do a class on My Client Died, Now What?
Oh wow, that's a good. You know, Miss Barbara, one more question. I hope I ain't asking too many questions, but Miss Barbara, Miss Phyllis speaking just reminded me of the question. Miss Barbara, you remember when you went and said about making sure that you send a form about getting paid in areas outside of Atlanta or areas outside of the MLS that you're actually part of?
Oh, yeah. Mhm.
Can you explain that?
Okay, I'll be real quick.
Okay.
Basically, what I said is, if you're down in Savannah selling properties and you're not a part of their FMLS, you need to contact that realtor and send that document over to make sure that you're gonna get your commission in the event that that your buyer writes a offer down in Savannah, because of the fact you are not, your MLS is not down in Savannah. They probably have a different MLS. So therefore, you're gonna need that person, that realtor, those resources down in Savannah to get your contract through. So they're gonna be doing a little more work than they normally would be doing for you on your contract. So you're gonna make sure that there's an agreement that if you bring this buyer, you will get paid your commission. Because you are working outside of your MLS.
Or if you're showing a FISBO, the same thing.
That's correct.
And
Pocket
what-
listing, FISBO, all of that.
And what form is that?
It's called a commission confirmation agreement, Barbara, isn't it?
It's something like that. Let me see if I can find it real quick.
Is it in
Yeah,
our
and like-
regular GAR forms?
Yeah,
It is.
it's in the GAR forms. My class next Monday is amendment stipulations, earnest money, and terminations at 1 o'clock here.
Oh
in
my
Atlanta.
God.
Oh my goodness. Eileen, do you do those by virtual or they're all in-house?
They are on Zoom. I'll put the URL in the chat.
Eileen, what's that class again you're gonna teach?
Next week, I teach these on a rotating basis. It's for brand new agents, but experienced agents often piggyback into the classes. Next week is amendments, stipulations, earnest money, and terminations.
Oh yeah.
This week, we're doing finance and other contingencies. And what else is today?
Is there a way you can send us
Exhibits and
that Zoom
brochures.
link for today?
Yeah, I'm putting it. There's the URL in the chat. So you just go to contractsclass.kwarma.com, KWRMA, and you can zoom in. I teach them pretty much rapid fire. You've got to know what I'm teaching. The new agents have a book with all the contracts already set up in them, and I teach them in a specific order. But anyway, they get the book because they pay fees for that here in this office. So, but if you've got any experience with the forms, you should be able to pull them up pretty quickly and keep up.
Is that book accessible to other agents for the fee?
We would have to talk about that. We'd have to
Okay.
talk about that. So.
Gotcha. Well, this class has been great, Eileen and Ms. Barbara.
Yeah, I appreciate Barbara's help. She's on I think she's gone now. She's on the forms committee and she has a lot of insight into, oh, there she is. A lot of insight into why these forms get changed and in the manner that they're changed. And they've done some really good things the last couple of years.
Yeah, I'm looking for that. I'm looking for that form number that she just asked me about, but I will.
Did you find it?
No, I did not yet, but I'll find it and I'll get it back to her and I'll let you know also, Eileen, in case someone else asks for it.
Yeah, hang on a second. I might be able to pull it up. Oh, I know what it's in. I'm pulling it up by the sections where I teach the classes.
Ms. Barbara Ezekiel, just to clarify, is this exception exclusive to Savannah, or is it Southeast Georgia or Middle Georgia? Where is it, that market?
It's exclusive to wherever you try to sell real estate outside of your MLS area.
Okay.
It's an F-258 co-op commission agreement.
Thank you, Eileen.
58.
I was just texting Christina to ask her. Thank you.
Yeah.
F-258.
Yes, ma'am. So,
Okay, got it.
anything else?
No.
Okay, well, I'm gonna go get ready for class, but again, I do appreciate everyone's participation. And you've got my email address if you ever have any other questions. And certainly if you have, think you might be running into a 10-day letter situation, please ask the question before everything disintegrates. But if it does disintegrate and we do go to the point we have to write a 10-day letter, that you'll be interacting with me on that.
I'm sorry, I logged in a little bit later. What time is the other class that you sent the link to?
1.
It's at 1 o'clock.
Okay, thank you so much.
That
You're
sounds
welcome.
like Stephanie. Miss Eileen, I don't see the link for your 1 o'clock test. That's not the contractclass.kwrma.com. Is
Yep, that's exactly it. Contractsclass.karma.com. You just type that into your browser and you will be admitted into the Zoom.
okay. Thank you, Miss Eileen. Have a great day.
You're welcome. You guys also.
All right.
Thank you. Bye-bye.
All right. Bye-bye.